Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking, your go-to YouTube channel for insightful discussions on legal matters that impact our community. I'm your host, Melanie van Orde, a licensed paralegal dedicated to bringing you valuable advice and need-to-know information on a wide range of legal topics. In today's episode, we're diving into a critical and often misunderstood issue, youth and domestic assault charges. So joining me today is Phil Stiles, a seasoned legal counsel with extensive experience in criminal law. Together, we'll explore the complexities of how domestic assault charges affect young individuals, the legal consequences they face, and the support systems that's available to them. Phil, what are the differences in the legal process for youths compared to those of adults in domestic assault cases?
Well, in domestic assault cases, really, it's night and day compared to anyone being charged as an adult. The differences don't have to do with the criminal code offense. So in other words, it's the same elements of the offense for a charge of assault. It's the same law that applies to whether there's an offense committed or not. But the way the court deals with a youth, both before and after a conviction or trial, is night and day compared to an adult. So there's a number of examples of key differences. One example, Melanie, has to do with the way sentencing works. So everything from the principles of sentencing right to the terms of probation, if imposed, it's completely different. So the sentencing objectives in a youth case will always be rehabilitation. And the concept of denunciation and deterrence will only apply to specific deterrence, i.e., what is it going to take to deter this youth in the future, not general deterrence, i.e., what is it going to take to deter all youths from doing this in the future. So no youth will ever be hung out as an example. In domestic cases, it makes a big difference to be charged as a youth, because if there's a breach, for example, you're much more likely to be granted bail and much more likely to be not held for bail by police. So there's a number of differences in the two types of systems. Again, the same charges, but different way the court deals with you.
And then what role do parents or guardians play when a youth is charged with a domestic assault?
When a youth is charged with a domestic assault, parents have to be informed at the first opportunity after a charge has been laid. Usually, parents are informed almost upon arrest or shortly thereafter. If someone's under the age of 18, police must make the call to a parent. There's other ways that parents get involved. And another example is if a statement is ever going to be taken from a youth, a parent has to be present throughout the statement if the statement is to at all be admissible in court. So both the parent and the youth have to sign off on a multiple step process police have to go through to make sure both the youth and the parent understand the nature and consequences of giving a statement. Often it isn't complied with and the statement isn't valid. Another example is that parents have to attend court with the youth unless the youth is represented. And the court has to see proof that notice of appearance has been provided to the parent as well, that the parent has been notified of the youth's court date. Parents are very involved in the process from start to finish, and it can become tricky as a lawyer because your client is the youth, not the parent. Parents will naturally want to speak directly to you about their son or daughter's case, and you can't without permission.
And then, what advice would you give to a young person who finds themselves facing domestic assault charges?
My first bit of advice is try your very best not to breach. I can't stress that enough. Usually, there's some type of charge that is likely to get resolved fairly quickly, that's likely to lead to a non-criminal resolution and avoid a trial and all of that. But the client goes out and makes contact with the complainant or does something that results in a breach charge. The defense loses all of its leverage in the negotiation process because it may be difficult to prove that there was an assault, and there may be valid defenses like self-defense, defense of property, defense of another. But for a breach charge, the Crown just needs to show evidence of the text message, or that there was a phone call, or that someone's voice was recorded usually, and therefore the allegations made out. The Crown is, or the defense is deprived of all its negotiating capacity because the client is absolutely hooped on the breach, regardless of what happens to the original charge. So that's a big piece of advice. Don't breach. I guess another piece of advice I have is everybody wants to, or the natural inclination is to tell everybody about what really happened, right? And to clear your name with any member of the public, parents, teachers, friends. But at the end of the day, the best strategy is to keep your evidence to yourself and present it at one time only, and that's in court. If you have to, and if you don't have to, all the better. But essentially, keep everything to yourself until your case has been dealt with by the court. Those are two topics that jumped into my mind when you asked that question.
Thank you so much, Paul, for joining us today. And thank you, everyone else, for joining us today on the Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.